Right, we'll start, I think. Good morning, everybody. Welcome to our second top tip session of 2021. For those who are regular attendees at our top tip sessions, you'll know that we are very rarely stuck for something to talk about or stuck for topics to cover in our sessions. And we're largely informed by what we cover, by the feedback that we get to the surveys we send out after our sessions. So today we're going to do something slightly different. Rather than cover one topic or two topics, we're actually going to cover six different topics. So 5 of those are, I think, probably what we would call frequently asked questions. So they are the questions that are coming up in the surveys that we send out to you after these sessions, and they are the issues that we find ourselves as a team and as a practice dealing with most regularly. So these are our kind of top 5 thorny or tricky issues and our kind of, I suppose, best tips and top tips for dealing with those issues. We decided to add in one ourselves at the very end, and I will come back to that, but it's just to take you through a decision of the Supreme Court, which issued just over 2 weeks ago, and the impact that decision is having on how the Workplace Relations Commission deals with hearings, which are before it and which will come up in the future. Before I start, I want to welcome my colleagues, Connolly and Avril Daly, who are joining me in today's session. And before we jump in, I just want to remind you, so as I said at the beginning, you will get a survey after this and it's feedback on the session, but it's also a request for suggestions around topics that you would like us to cover in the future. We also have a question and answer box at the bottom of the screen that will come up very shortly. We do have time, we've included time for some questions and answers at the end. We frequently get far too many questions to get through, so I'll try and lump as many of them together and deal with the broad topics, but please feel free to pop any questions that you have into the Q&A function at the beginning. So we'll start, and we'll start by saying at the last session that we ran on the 11th of February, we covered remote working. And we looked at the challenges of remote working, and Orla spent some time taking attendees at the session through our tips for what should be included in an employer's policy in relation to remote working. And Ronnie spent some time just taking attendees through issues around the challenges in particular of trying to manage people who are remote working from a different jurisdiction or abroad, and there's peculiar tax and social insurance and legal issues around all of that. Today, we want to focus on one issue in particular, and that's the challenge of managing an employee's time, working time, when they are working remotely. So this is just about working time, because the challenge of managing employees' working time is something that we've been having to deal with since the introduction of the Organisation of Working Time Act back in the late 90s. And for anybody who's had the misfortune of having to delve into that act, it's short, but it's particularly difficult to comply with. It places obligations on employers to make sure employees aren't working over 48 hours a week and they're taking the proper rest breaks. And it also mandates employers to record employees' working time. And whatever about how that's done when somebody is physically in the workplace, that is going to be more and more difficult to comply with for employers who are trying to manage employees who are working remotely. And with that in mind, the government on the 1st of April published a code of practice around the right to disconnect. So Avril, I want to start with you. Talk to me first just about this right to disconnect. Where did it come from and what does the code of practice say?
Okay, so obviously there's a renewed focus on this in light of the new code of practice, but it's actually nothing entirely new. As you say, restrictions around working time have been around a long time by virtue of the Act, but the Act was obviously created at a time when the workplace and working practices were very different to how they are now. And the new code of practice tries to address the fact that restrictions around working time and the ability to switch off from work for a lot of people has somewhat been forgotten about as work has become more accessible in terms of how and when and where your employees can work. So the professional and the personal are kind of morphing into one in the home, especially, and employees are finding it harder to disconnect from work. So that's what the code of practice tries to address. It tries to make sure that employees are aware of their right to disconnect outside their normal working hours.
And Avril, then the highlights of the code, there's a few kind of basic landing points in it. What are they?
Yeah, look, there's a lot of aspects to it, but the key things that we think employers should be aware of are, first of all, remember that the code applies to all employees irrespective of where they work. So whether that's the office, at home, or some other remote location, and regardless of what their working pattern is, they should be able to disconnect from work outside their normal working hours. Secondly, and really the main thing the code wants you to do, is to develop a right to disconnect policy that's customized to your business. And you'll need to give training to managers and employees on their policy and on the appropriate behaviors for disconnecting from work outside their normal working hours. And, I think if you have people in some of the larger tech companies, especially, people reporting into managers in different time zones and in different countries, those managers need to be made aware of this new policy and they need to be trained on it. Then you can also look at, think about using email footers to remind other employees and clients and customers that there's no need to reply to emails out of hours and that people shouldn't expect an immediate response. I've certainly started to see that on some emails coming in from various clients.
I have been quite critical of the code publicly. I don't think that's any secret. But because I have a concern about the impact it has on kind of flexible working, if you like, and the ability to collect kids from school or do a run or go to the gym or go to the supermarket during the day. But what happens if an employer doesn't comply with the code?
Well, not a whole lot really in practice, because the code only sets out guidance. It's not law in itself, and failure to follow it is not an offence. That said, I think we are going to see more cases as a result of the code. So employees can obviously bring a complaint under the Organisation of Working Time Act, as they always could have. But that claim is likely to be strengthened by the code. So you can't ignore it. And I think, we might start seeing slightly higher awards in the WRC as a result, but we'll have to see what happens.
Because there's a fairly big stick in the working time legislation. I mean, the ability to award up to 2 years' pay as compensation is, and it's compensatory. It's not linked or limited to anything. So it can be quite significant, actually. What do you think the workplace relations view will be when it has to deal with these complaints? Or is there any experience so far around kind of working time and remote working?
So far, we haven't actually seen any cases directly on the issue of, an employer failing to record working time of remote employees, or an employee complaining that they're working longer hours due to remote working or due to COVID. When WRC complaints are issued, they tend to occur in the context of a broader dispute over termination of employment or some other bigger issue. Employees will tag it on to their complaint. But having said that, it could well be that these claims are yet to be heard. We are still waiting to see the full fallout from the pandemic and the effect of the code.
So the code says have a policy. There's a kind of template policy or details of what should go into the policy at the end of the code. It talks about things like putting, email footers on, and we're all seeing those now. My normal working hours are A to B or whatever they are. You mentioned there the tech companies where people are reporting into somebody who's in a different jurisdiction, different time zone, different country, different part of the world. What's your top tip for employers at two fronts, grappling with how they're going to manage the working time and record the working time of individuals who are working remotely, and your top tip around this kind of right to disconnect and the rollout of a policy? So 2 tips I'm asking you for, Avril.
Well, I think, first of all, you really need to train your employees and your managers to respect the right to disconnect and to communicate your policy to everybody in your organization, and to look at your time recording system. I mean, most people have pretty sophisticated ones these days, but to make sure it fits with this new remote working.
So while it's not binding outside of the jurisdiction, it's really important that managers know about this right to disconnect. There was lots of chat when it happened in France. Okay, so communicate the policy is your top tip, and look at your time recording system so that you've got some sense of how employees, how long they're working in the day. Yeah, because it is a struggle when people are at home, and I think everybody appreciates that.
Yes.
Ger, I want to talk to you then for the second issue that our second frequently asked question, if you like, and that is, how do you manage a disciplinary process when somebody goes on sick leave? Because it's something that we've all had to deal with, particularly over the course of maybe the last 10 or 15 years. There's this increase of instances where an employee is put on a performance improvement plan or put into a disciplinary process around anything, and the next thing that happens is the sick cert comes in and the employee is stressed and they're not coming into work. So, like, first question, can you continue a disciplinary process when somebody goes out on sick leave?
You can, but it's just extremely difficult. We've got into a situation where we now, when the certificate comes in, a pause is kind of pressed on the disciplinary action, and then the disciplinary action kind of becomes secondary, and we head in towards, if you want to call it, a medical dispute. And the medical dispute has a number of grounds. As one is, we end up sending, as in the employer ends up sending the employee to the company doctor, and you ask questions such as, is the person fit for work? If they're not fit for work, are they fit to participate in a disciplinary meeting? And the answer is generally no, compared to those two questions. And then you go on to, well, when will the employee come back to work? And I think it's not uncommon for disciplinary action to become paused for a considerable period of time, and the disciplinary action can still be outstanding 6 months later. I had one case many years ago where the gap between the invite to the disciplinary meeting and the meeting itself was over 3 years, where there was a simply circular effect of the concept of being disciplined or being put in a PIP was having an effect on the employee. So can you continue with a disciplinary process? You can, but it would be a very brave employer that would push you through without going through, if you want to call it, one round, if not 2 rounds of a medical report cycle about fitness to either return to work or just participate in the process.
And I think there are different questions out there, and there are questions that need to be asked of a doctor. Is this employee fit to work? And irrespective of whether this employee is fit to work, are they fit to engage in the process? And they're different.
Correct, yeah, I think
it strikes me as odd sometimes how many times we see organizations sending people for medical reviews, but not actually asking the questions they want answered. You're paying for the review, ask the questions. Don't be afraid to ask the questions you want answered, which is, even if they're not fit to work, can they engage in the process? And I think that's important. What if then, like, I suppose, next question, can a disciplinary meeting be held in the employee's absence?
It can, and my view is that you must afford the employee a reasonable amount of time to, if you want to see, get fit for the disciplinary action. But there will be a tipping point, and it's different. It depends on the nature of the allegations, how serious the employee, how senior the employee. But there will be a tipping point where an employer will have to just simply push on with the disciplinary meeting. Otherwise, it's going to end up in a situation where the employee is going to remain on sick leave. The disciplinary or the PIP is going to remain outstanding. And you actually run into, what can happen is your witnesses or the people that's in charge of the process will actually have left the organization. So you'll end up with a very clumsy or cumbersome process where you're actually missing people. A recent case I had, we decided after 8 months of effectively the employee being unfit for work or saying that they won't participate, including asking the employee, would they even commit answers into writing? So we've gone with a very low common denominator. You can't turn up, but can you just respond to allegations, of which they did say again that they were unable to respond. The employer pushed through with the disciplinary action. And in that case, the WRC felt that it was a reasonable period of time, in that 8 months, you can form your own view whether it's too long or too short, whatever, but they felt that 8 months and proving that significant effort had been made to get the employee to the meeting was enough to warrant it continuing.
I think that you call it significant effort. I've done this recently as well, and successfully managed to defend a dismissal in those circumstances, but I wouldn't have described it as significant effort. I think I described it to the client as bending over backwards. which is, like, as you say, at least 1 or 2 rounds with the occupational health advisors, and lots of patience and lots of efforts to accommodate. And if the more hoops you jump through, or the more effort you make, the more bending over backwards you make, the more likely you are to be successful in defending a decision to process, or to continue through the process. But the question then is, Ger, whatever about conducting the disciplinary process, can you dismiss an employee who's on sick leave? And I suppose there's a distinction between an employee who's on sick leave that you're managing through a capability process because they're too ill to ever be able to do the job. That's not what we're talking about now. We're talking about an employee who goes out sick after a disciplinary process has been invoked. And there's a distinction between the two, I think.
There is a distinction. I think the answer is, again, yes, you can dismiss the employee who is on sick leave while during a disciplinary. I think it would be important that if you, and I think we're seeing this more often, is that when you have effectively implemented a dismissal, that an appeal would be granted. An appeal should be granted in all disciplinary actions. But I think for the employer, at least at that stage, in a crude sense, the employee is off your books. An appeal is outstanding, and in your defense of the claim in front, be it the WRC, or if you went into a civil court in more dramatic situations, you will be saying, but there is still an avenue for this employee to defend themselves when they get fit for work, as opposed to simply, I suppose, languishing on either your payroll or just being an employee, which probably after 8 to 12 months, a lot of people will nearly have forgotten the central allegation and the person.
Well, you mentioned payroll there, Ger, because I mean, that I think is probably one of the issues that's most frustrating for employers, that they start a disciplinary process or start a performance improvement process, and the sick cert comes in, and not every organization has a sick pay scheme, but lots of organizations do. So the employee who they're trying to discipline or trying to performance manage is then on sick leave, and that employee is getting paid for up to 6 months in some circumstances, because we often have that conversation with clients. You start this process, the employee goes out sick, and then you end up paying them for 6 months while they send in the medical certs. And there are very few doctors around the country who will challenge that. And maybe that's, I don't want to tar all doctors with the same brush, but it seems to be relatively easy from our combined experience to get a medical cert that says you're stressed and shouldn't go to work, or that you're suffering from work-related stress. So what about sick pay? Does an employer still have to continue to pay sick pay in circumstances where it has invoked a process and innocent until proven guilty and all of that?
Yes is the answer, depending on what your policy states, but the majority of policies would simply say if you go on sick leave, you're entitled to being sick pay. And as you said, a lot of people don't challenge, or we're not in a situation to challenge the medical evidence unless your own doctor. What we have seen is, I won't say it's a trend, but we have seen policies that do explicitly state that no sick pay, or sick pay will be ultimately discretionary, and where an employee goes on sick leave following either the invite to a disciplinary meeting, or even before that, an invite to an investigation meeting. So effectively, we've seen certain policies which are carving out from their sick pay policy a caveat of you will not be paid if you go on sick leave during a disciplinary process. And it's very effective, because I think, as you said, Melanie, there's a big correlation between sick leave and the employee effectively using all sick leave, and then Lazarus, they're miraculously able to attend once the 6 months has expired.
Yeah, and I suppose, just to be clear, we're slightly cynical about it, because we only ever see it when an employer, a HR practitioner, a people manager comes to us because an employee's gone out sick, and they're a little bit skeptical about it. So it has to be said, there's lots of situations where an employee's sick leave would be very genuine and unrelated to the disciplinary process. And that's where the discretion piece comes in. I want to move on, Ger, but very quickly before I move on to the third issue, give me your top tip for managing a disciplinary process when somebody's gone out on sick leave, or somebody sends in the sick cert.
I think the top tip is, I think you just probably two. One is have a look at what your sick pay policy is actually stating in relation to sick pay and disciplinary action. And I think the second thing is, look, it's not a tip, it's a reality. I think you're going to have to be quite patient. There's no quick fix to a 20-year-old problem.
Okay. I want to move on, Jeremy. We're going to stay with you for the third issue, if you like. And this is kind of more a set of questions than anything else, because one of the things that certainly when I qualified 20 years ago, we didn't really talk about investigations much. And yet now there is a whole industry of investigators, and the conduct of investigations, whether it's in the context of a grievance or in the context of a bullying complaint or a harassment complaint, or in the context of a disciplinary process where facts have to be established around an allegation about somebody's conduct. There's this whole industry now of investigators and those who conduct investigations. Lots of larger organizations have internal investigation teams, but it's not something that's regulated. So there are a couple of questions that come up time and time again where practitioners grapple with the answers. So there's a few of those we just kind of want to touch on again. And this, like I said, this is the third topic, but there's a few questions within it. And the first question that we get asked all of the time, and the one that comes up in the surveys as well, is, does the investigator have to share all of the notes, whether the notes are with the complainant, the person against whom the complaint is made, so the accused, or the witnesses? Does the investigator have to share all of the notes with the person against whom the complaint is made?
Yes.
Yes.
It's
and we have a particular reason for kind of landing on that view, don't we?
Yeah, well, I think there is firstly, all investigations, there's the undercurrent of what is fair procedure and natural justice. You know, we hear it bandied about. What does it mean in practice? The means in practice is you have full understanding of the allegations that are being put against you, and the documentation that's supporting those allegations, and you're given a response. And if you look at the various codes of practices, and we have a new code on bullying that was issued in December of last year, it's explicitly stating under its formal procedures that the copies of witness statements, copy of the complaint and the response, that they should be provided to the complainant. So I think it's important that those who are conducting these investigations, and I agree with your point, investigations now seem to have become more topical than the disciplinary, or if you want to call it the follow-on event. I think it's a game of stop the investigation and therefore you'll never get to a disciplinary action. But I think you have to accept that there are very open book process, and an investigator or a person charged with investigator will need to be extremely careful about what's being committed to writing. There can't be two sets of notes. There can't be an official set and an unofficial set. And
I think that's a big challenge, actually, because the reason we get calls a lot of the time is because an investigator is saying, oh, well, Avril said that to me in confidence, or Avril said that to me off the record. Well, like, if it's going to form part of the investigation and impact and influence on an investigator's outcome, and it has to go in the notes, it has to be shared. And I think that's a challenge for investigators in particular, isn't it?
I think so. I think an investigator should have the rule that there's nothing is confidential. And the employee who is being interviewed, or the witness, has no right to confidentiality. Particularly where, and you can see the logic behind this. If you're told something in confidence and it's not included in your report, but it could have a weighting, and therefore your report is actually being tainted by something which is held in private between two people, and ultimately where these get litigated to the end, when it would be a very awkward day out for the investigator, where either A, his or her notes are discovered, which they have additional information, and B, they're being cross-examined and they're being asked somewhat awkward questions of reasonings behind their report, yet they're saying, well, it was actually a private comment that had an influence.
And it's something that we've seen very uncomfortable. I have one other question I just want to ask you on investigations before we move on, Ger, and it's this. So we've had buried in our code of practice around disciplinary processes, which dates back to 1980, so it's 40 years old, there's a reference to cross-examining accusers and witnesses. And it's not something that arose that much as a matter of practice, you know, in the last 40 years that I can see from case law, or that we had that much experience around. But in the last 2 or 3 years, this right to cross-examine, and cross-examine might be the wrong description for it, the right for an accused person to challenge their accuser or challenge witnesses. Talk me through that, because again, that's an issue that's coming up increasingly in the context of investigations.
Yeah, I think the important point is it's not a new right. It's a right that was there, but it was buried. And I just don't think it was used. And there was a case a number of years ago in 2017 that effectively, if you want to call it, rekindled the right. The High Court judge said cross-examination is a vital safeguard. And a lot of people jumped on this. And of course, there's a sinister, being cynical, there's a sinister use to it, is that where the complainant simply wants to frighten witnesses and stop witnesses participating. But there's an element of, you have to wonder, you know, particularly when we talk about the Supreme Court's decision about how the WRC is going to operate, or should be operating in terms of evidence. Like at some stage, the person making the allegation, be it in the process itself or in the WRC, will face cross-examination, and together witnesses will face cross-examination. So I think it's an element of, it can't be ignored because it's going to happen at some stage, be it in an internal process, which a lot of employers simply don't want it to allow it to happen because it effectively has created a court setting in a private company or a public sector. But cross-examination is a live issue and it's not going away.
Yes. So, Ger, very briefly, in 20 seconds, your top tip for any organization facing into any kind of an investigation?
I think there's no such thing as confidentiality, as in, you know, you can't have. There's
confidentiality within the process.
But I think no one should expect that who participates to have, if you want a dual track process, as in information that's available to the people, but then there's a stockpile of separate information. And I think what I would say is you need an experienced investigator now, because investigations are topical much more than actually the disciplinary process that would subsequently follow.
Agreed. Right, thank you, Ger. Avril, I want to come back to you for our fourth topic, our fourth frequently asked question, and it's this: can I bring my lawyer to a meeting, whether it's an investigation meeting, a disciplinary meeting, a performance review meeting? Can I bring, and it particularly arises, I think, in the context of disciplinary hearings, can I bring my lawyer?
Okay, in general, the rule has always been no. An employee does not have the right to be legally represented in an internal disciplinary meeting. But the codes of practice are silent on the question. So our code of practice on grievance and disciplinary procedures, which, as you said, is really old at this stage, says that employees can be represented by a colleague or a trade union representative, not somebody unconnected with the business. Likewise, the new code of practice on bullying, although obviously it's related to bullying, it says the same thing. It says that, you know, you can bring a work colleague or a trade union rep, but it also goes a little further to say that representation should be in line with natural justice and fair procedures. So it doesn't specifically say you can't bring a lawyer. And because the codes are silent on it, we really have to look at cases, at case law. So from after decisions in 2017, the trend was that if dismissal is a possible outcome of a meeting, well, then you really should be allowing the employee to bring legal representation as part of their right to fair procedures. That's it if they ask for it. But more recently,
was a change from the laws that had been previous to that.
Yeah, exactly. And more recently, the case law has said that there has to be exceptional circumstances to bring a lawyer. And it's not as simple as saying, you know, if dismissal is a potential outcome, which, let's be honest, it often is, that the employee has to be, you know, allowed to bring a lawyer in all cases. So the Supreme Court said in a case some of you might be familiar with, McKelvey and Irish Rail, they stressed that really the question should be, is legal representation necessary to make the process fair? Or is it just that allowing representation could potentially help the employee throughout the process? Because, you know, if there are particularly difficult issues of law or extremely complex facts, well, that might suggest a lawyer should be allowed to attend. But in that case, the court said, the facts related to a question around fraud in connection with petrol expenses. And it wasn't something massively complex that the employee couldn't follow himself. And so they said it didn't necessitate legal representation. So you kind of have to apply a bit of common sense to the facts and the circumstances. But one of the things that the court focused on in that case was that the employee was allowed to be represented by an experienced trade union official. And they also said that the employee could renew his request at a later stage in the process. So I think if the circumstances were different, and for example, the only option was to bring an inexperienced colleague, the court could have a different view. So you kind of need to look at it case by case. And look, we're aware of one client that just says no at all times. They, regardless of the nature of the disciplinary, they just feel the whole process will turn into a zoo. So they say no to lawyers in all cases. And I think while a lot of the time you can say no, in our experience, you're sometimes better just agreeing to the request to facilitate the process and to avoid the sideshow becoming the main show, because it can distract from the central issue, if you say no. I think on balance, the key thing is to review each person's request as you go along and at each stage of the process, but be open to allowing legal representation just in the interests of getting through the process. And just to say, I suppose, if you do allow a lawyer to attend, be clear about the role that they will play in the meeting. So, explain that they won't be allowed to make representations on the employee's behalf, but maybe let them make a closing statement or maybe send in submissions afterwards.
It's interesting because I think our view as a practice is that lawyers have, as a team, is that lawyers have no place in the internal meetings. I have been at one disciplinary hearing in my professional career, and the person being disciplined was a solicitor. And most kind of experienced employment lawyers know that the internal meeting isn't a place for them. And there's two reasons for that, actually. If a lawyer attends a meeting, they then become a witness. And it's hard to be a witness and an advocate if the matter becomes contentious. And it also means that if the lawyer doesn't raise concerns about the process at the meeting, it's very hard for them to do afterwards. So it's not something that I would recommend any lawyer do. What then, Avril, and you might be brief about this one, what about the people that come and say, I want to bring my mammy or my brother or my husband or my boyfriend or my girlfriend, and that's more common in small organizations and not entirely, unreasonable, I think.
Mm-hmm. Yeah, I mean, look, I think if you go back to the codes, they're talking about a trade union representative or a colleague. So, and I think your policy needs to make it clear, a disciplinary procedure needs to make it clear who is allowed to come, but usually we'd be saying no to those kind of requests. So you're not going to bring your neighbor, or your mommy or your daddy. It needs to be somebody connected with the business. I think you're better to limit it to that.
Yeah. Okay. Ger, back to you for our last category, if you like, our last frequently asked question. And that is around where an organization or a people manager or a HR practitioner starts a disciplinary process or starts a performance management process. And not that the employee goes out sick, which is something we see quite commonly, but that the employee then files a grievance or makes a complaint about the person disciplining them or the person performance managing them, says that they're bullying them, or says that they are retaliating against them for something unrelated. Does an organization, when that happens, when the employee being disciplined or being performance managed makes a complaint about the person running the process, does the organization then have to pause the disciplinary hearing to deal with the grievance or deal with the complaint?
It doesn't have to pause the disciplinary process, but it can't simply ignore that a grievance has been lodged. And obviously the grievance is used to block the disciplinary process. It's usually along the lines of, my manager has been bullying me, so the disciplinary process, or the PIP, is actually is just another, if you want to call it, another facet of the bullying I have suffered. It becomes very difficult, and you end up having to run concurrent processes. And it's important when you're running a concurrent process, they're not concurrent with the same individual. You shouldn't have the person who's doing a disciplinary person effectively getting two jobs, disciplinary and grievance. So ideally you'll end up with, and it sounds adding more workload, and the reality it is, you should end up having separate processes. So you will have a disciplinary person dealing with a disciplinary and a performance. And what I have seen is a disciplinary meeting happen and it effectively being paused prior to a sanction being imposed, and then the grievance being dealt with. And then once that's closed out, effectively the disciplinary sanction being announced or imposed. So there is, the disciplinary doesn't have to be paused, but there certainly has to be something done with the fresh complaint.
Okay, so your top tip, Ger?
Top tip is you're going to have to deal with them concurrently, but make sure it's different individuals, and don't let if you want to call it a performance and a grievance, get intermingled into or lumped into one thing, because it will be very difficult for that person to ultimately decide upon both.
Okay, thank you. They are our, I suppose, 5 thorny challenges that we come across regularly. We have a good few questions in that I'm going to come back to in a couple of minutes, but before we do that, we just wanted to talk you through something that is going to have quite a big impact on employers and organizations going through the Workplace Relations Commission process. So the Supreme Court, like I said at the beginning, yesterday, 2 weeks ago, so on the 6th of April, issued a decision in response to a constitutional challenge to the constitutionality of the Workplace Relations Commission and how effectively they run hearings. So for those of you who are old enough, you'll remember that we used to have a rights commissioner service and an employment appeals tribunal, and how the employment appeals tribunal cases changed quite dramatically in 2015 when the Workplace Relations Commission took over. And this constitutional challenge arose out of an unfair dismissal claim. And it's always interesting where these things come from. An unfair dismissal claim by a security guard in a shop on the North Strand. So he was dismissed and he filed an unfair dismissal complaint. The matter ended up in front of an adjudicator. The case was adjourned. Both parties and both sets of lawyers rocked up on the second date, met the adjudicator in the hallway, and she at that stage had already issued her decision. And it was a mistake. It was clearly a mistake, but it formed the basis for a constitutional challenge. And the Supreme Court, in a majority decision, because there were judges who didn't necessarily agree, the Supreme Court has upheld the constitutionality of the Workplace Relations Commission, so it is going to stay there in general terms. But it did express some concerns about how cases are run. It also expressed the view, various judges expressed the view that adjudicators are involved in the administration of justice. And in circumstances where adjudicators are involved in administering justice, there are 2 aspects of what they do that the Supreme Court found unconstitutional and will have quite a significant impact on how adjudicators run cases going forward. So that's cases around dismissals, payment of wages, working time, we touched on those earlier, equality cases. So Avril, you might just talk us through those 2 issues in particular. So something anybody who has a case in being or is trying to defend a case or is bringing a case in being before the Workplace Relations Commission now, and for all cases in the future, there's 2 pieces in particular that they're going to change and going to have quite a dramatic impact on how cases are run.
Yeah, so what the Supreme Court has said is that the blanket requirement that hearings take place in private is unconstitutional, and that from now on they have to be in public. They also said it was unconstitutional that adjudication officers can't take evidence on oath. So the legislation is going to have to be changed, obviously, to reflect that. Practically, what this means going forward is that the parties' names will no longer be anonymized when cases are both listed for hearing and also when decisions are published on the WRC website. So both of which, the public will have access to. And as you say, it's kind of going back to the format of the old EAT. I think it's really going to have an impact on the strategy used and the time spent when handling disputes, because part of the idea behind getting rid of the requirement for taking evidence on oath was to try to shorten the time frame for hearings. But bringing this in again will impact the length of the hearing. And it does also mean that swearing up to something that's false is a criminal offence. So in practice, we've already seen cases being adjourned where one of the parties wants evidence to be taken on oath, even if the case has been partly heard. And in terms of the public element of the hearing, remember now, this means that any member of the public or the media will be allowed to attend. And with COVID restrictions and remote hearings, that's actually going to be a lot easier for people to just log on to a virtual hearing for 40 minutes or have it on in the background rather than physically trekking down to Lansdowne House, because people can just send an email asking to attend and they're going to get a link to the hearing. So if you're concerned about publicity, you might want to consider moving to mediation or to an early settlement, because the changes don't apply to mediated cases or to claims under the Industrial Relations Act, because of course decisions under that legislation are non-binding. So it's really, we have to wait and see what happens, but I think WRC themselves are still trying to grapple with it.
There's a question here, actually, Avril, while you have the floor. Do you think these changes will lead to an increase or a decrease in the number of claims?
Probably an increase, to be honest. I mean, if claimants are aware that, you know, it could be used as a bit of a negotiation tool by claimants if they feel the employer is going to have concerns around publicity, like they could just take their chances and lash in a claim.
Ger, there are a good few questions here around investigations, so I am going to come back to you if you don't mind, and they're tricky ones. So there's one here, and I think the answer to this is very straightforward. So I will put it to you first. When it comes to sharing the notes of the investigation, is there a difference between when it's a disciplinary investigation or a grievance investigation? Must they always be provided?
There's no difference. They're just, we don't make any distinction between the law makes no distinction between them.
Okay, here's another one, right? And it goes back to, I suppose, this, anything you say will be shared, and anything an accuser or a witness says may be the subject of a challenge, whether it's by cross-examination or some other challenge. There's a question here that says, is an employee who's a witness to an event or an incident obliged to participate in the investigation?
No, they're not. It's a free thing, and we've had situations where I think employees have participated in the investigation, but then where they realize it's trending, if we want to call it, towards a WRC and given evidence of on oath, we have seen employees said, I didn't sign up for this, and they have reversed out, or they have, if you want to call it, may leave their statements there, but they're not going to orally stand over their statements or become a witness. So but it's up to a witness themselves to agree or disagree to participate.
So another one then, Ger, on investigations. If an investigation involves multiple meetings, when are the notes issued to the person under investigation?
If there's multiple meetings, I would wait and gather them all up. There's no requirement that they're given out every single time. But what I have seen with a lot of investigations is that the investigation report is done and the notes become appendices onto the investigation. But I think if there's something critical within those notes, they should be shared sooner rather than later. I think stockpiling notes is never a good thing, but they don't have to be handed over, if you want to call it, concurrently as nearly as they're finalized, they're handed over. But I have seen, it has to be said, I have seen some investigators open up, if you want to call it, Dropbox accounts, and that they're constantly feeding in the documents into so they're visible to both parties as you go along. And given, I suppose, modern technology, what's wrong with that? The only thing, the fear, of course, is that before, if you have meeting one and the notes are shared, you have the respondent or the complainant putting in their next version, and then you simply get bogged down and you never get through a process. So
do you think it's better then to kind of amalgamate them all and share them at the one time at the end, or attach them to the back of a report?
Yeah, I think this goes again. I think yes is the answer, and I think this probably should be dealt with in the terms of reference, where it should explicitly say you'll get the notes at a particular point of time, because the investigate, unless you're a professional investigator, investigations are very time consuming. So you want to be seen to be making progress, because any investigation now probably will take a minimum of a month, and it could take 6 months.
Yeah. There's another one here, Jaron. I think the answer to this is very straightforward. If 2 employees are involved in an incident, can one person investigate both employees? Yes, because it's one incident, isn't it?
Yes.
Separate meetings then for each employee.
Separate meetings, yeah.
I might come back to you, Ger, in a second, particularly around the cross-examination point, but I'll give you a break for a second, because I have a couple here for Avril. So Avril, tricky one. Somebody says here, I'd say the time recording isn't as prevalent in tech sectors and multinationals. Do you think the right to disconnect is going to change that?
I think it'll have to. I mean, all employers are still legally obliged to record working time. That's always been there, and I think it's only going to be heightened now. So I think so.
I wonder, so the obligation to record is there since the late 90s. In some organizations and in some sectors, it's honored more in the breach than it is in the observance. Will this change it? I think what may change it is if there's a plethora of claims arising out of the kind of right to disconnect, or if there's an increase. And there was a case last year where the business development director said she was getting calls in the evening from California. Was it KeyPack or somebody like that?
KeyPack,
yeah. So will it change if there's a lot of claims? And what will be interesting now is that these complaints are going to be heard in public, and the decisions will be published and not anonymized. And the fact that there's a complaint against an employer will also be public. So it'll be interesting to see how it plays out, I think.
Yeah.
A very tricky one here down the end for you, Avril. So if somebody asks for remote working options, can we ask them for proof that their children will be attending a creche or that there'll be a childminder on the days when they're working from home? Ouch. Answer that, Avril.
I think that might be going a little bit far. But I mean, if you had concerns that the person wasn't working when they're meant to be, I think you would need to look into that. And,
not a question you'd be asking parents and people, not asking people who aren't parents.
Yeah. I think that's going a step too far.
Yeah.
What do you think?
I think it's potentially discriminatory, actually, unless an employer has evidence.
Themselves. Yeah.
And it's interesting because I think that always would have been a concern, that somebody working from home is not undertaking childcare at the same time. And this is part of my concern about the right to disconnect. I think until it's an issue, it really isn't an issue. And people working remotely with small children, and I include myself in that, when the creches weren't open and the schools were open, we all managed to keep the wheels turning. So it's not really an issue until it becomes an issue. But if somebody's not producing, then it might be an issue. And I think that's the point in time to actually maybe have the conversation around childcare. I'm going to stay on you, Avril, because there's another question here around the Supreme Court decision. How will evidence be taken under oath? I mean, we don't know yet.
Well, we don't know yet. I think it's WRC don't know themselves. They haven't really gotten into that in the statement that they've issued. And we're going to have to wait for the legislation to come in, I think, to be honest. And the adjudicators themselves are going to have to be trained on that.
A little bit like the Employment Appeals Tribunal used to administer an oath to somebody getting into the witness box down in Adelaide Road when the hearings were down there. But this requires legislation and then, as you say, training. So we're a little bit away, we suspect, from that happening. I mean, the legislation, will it take 2 weeks? Will it take 2 months? Will it take 6 months?
Yeah, and even when it does come in, we'll have to see how hearings actually run in practice then, because as we know, they don't always stick to how they're the prescribed format. They can be very different. So we'll kind of have to see how the adjudicator plays it on the day.
There are a couple of questions here about witness statements, the right to cross-examine, or the right to challenge, as I call it. I prefer to call it challenge accuser and challenge witnesses. And the sensitivity around that when the complaint is one of sexual harassment or when there's a concern about retaliation. They're two separate questions, but how do organizations deal, first of all, with kind of the sensitive issues around sexual harassment? Because, I mean, if you're in a criminal trial, there's a facility for somebody to give very sensitive evidence remotely by video link. But that's not going to happen in most organizations. How do you deal with that sensitivity around the sexual harassment complaints? Sensitive ones in particular.
Okay, well, that's great. I suppose in strict legal sense, there is no distinction between, if you want a cross-examination in a disciplinary credit card fraud versus sexual harassment. I think, and I've seen this before in a sexual harassment case, is where the employer dealt with it by saying, I simply am not going to allow this kind of challenge into a room where, you know, it's not going to be a court case. And it was done by way of written correspondence. When the case went to the WRC, a big hoopla was made about, if you want to call it, the fact that it was done in writing. And it simply got ignored in the decision. They actually never dealt with one of the key things of why the person, and maybe found on other grounds. So there is this sensitivity, and I remember years ago, a High Court judge, Mary Lafoy, referenced this about how uncomfortable she was by, if you want to call it, a small organization, a person who, if you want to call it, has been brave enough to bring forward a sexual harassment, and it was quite graphic sexual harassment in that case, and then it being, if you want to call it, a very rough and tumble civil kind of a full-blown trial before you even got to a hearing. She expressed her uncomfortability with it. So the answer is this: I think an employer is going to have to take a view that's going to have to balance, if you want to call it, the employer's right, the complainant's right to bring her claim, or bring his or her claim. But I think we sometimes forget there is a respondent who must be able to know the allegation and defend themselves. So I think there has to be a tipping point, and I think you have to look at it on a case-by-case basis.
And I think that if you want to cross-examine or challenge any of the evidence in particularly sensitive case, we've used that. Yes, we'll facilitate it, but you have to do it in writing. So set out your questions and we get written responses to them. We've done that with success several times, I think, throughout the team, and it's worked for us so far. So certainly it's not going to work in every case. And the thing about employment related issues in particular is that there's no one size fits all, but that's something that's a solution, I think, that we've used with some success several times. How about the second part of the question then, Ger, which is, you know, what about retaliation? Somebody won't come forward, give evidence, or won't stand over their complaint because they're worried about retaliation. And it's not strictly a legal question, but how do organizations deal with that?
Look, every policy talks about that there are, you know, a non-retaliation, principle, you know, effectively when a person should be assured that if they brought their complaint that they will be afforded and protected. Even the new bullying code is also making reference to, you know, people suffer penalization for bringing forward their claims. But it's the difficulty is this: these are, if you want to call, very formalized processes, but outside of that, there's a day-to-day working environment that is difficult, and that's the challenge for employers. How can you control all interactions? And this why it leads to a very, whether it's harsh, not, there's a commercial reality is that in a lot of cases, one employee leaves the business by way of either a dismissal for being found guilty of an offence, or a severance package is negotiated or something like that, because where you get to the stage where a grievance has been made, it is generally, even through mediation, it's quite difficult to bring the relationship back together.
Sure, thank you. Avril, thank you too. To our attendees, thank you for tuning in. You will get a Survey Monkey after this for feedback, but also more importantly, for your suggestions about the kinds of things that you'd like to see us cover going forward. There's been some asks for another kind of back to work session. We did do that before, and the recordings on the website, as are the recordings of all of our top tip sessions. Thank you for tuning in. Thank you, Ger and Avril, especially for the work that you put in to do this. We will see you all again soon. Stay safe in the meantime, and we wish you all well. Thank you.
Thank you.